Dubé. He has worked as court-appointed counsel in Los Angeles County. Philip, there have been a lot of motions in limine filed to address issues at trial. And I want to start with this first one about the state basically saying Bryan Kohberger's this alibi he's presenting that he's at this park and he's driving around, not really an alibi. And so Judge Hippler should tell them they can't present this at trial. Your thoughts on this?
Well, it's a little complicated, and I'll tell you. Obviously, he wants the jury to know that he was elsewhere at the time of the crime, that he was either praying and chanting and sitting in a lotus position, maybe doing Pilates stretches, looking at the stars, as opposed to slitting 4 students' throats, okay? And that might be true. Let's give him that. The problem is you have to disclose that upon a discovery request from the prosecution early. You can't just wait to the 11th hour. And there are reciprocal rules of discovery in the state of Idaho that require the defense to turn over all the facts surrounding the alibi, any witnesses who can corroborate it, any physical or circumstantial evidence or digital evidence that you might have. If you don't turn it over, it deprives the state of its ability to investigate it and to rebut it. The remedy is discretionary exclusion by the judge. So in theory, Judge Hippler could just say, you know what, you didn't turn this over, knock off this gamesmanship. There is now a doomsday sanction for this type of gamesmanship, and that is exclusion. So move on to your next defense theory. It's not going to be alibi. Now, on the other hand, you never want to deprive a defendant of a defense. And it is discretionary for a reason. There may be legitimate, good cause reasons why the defense did not turn it over. It could be that they were waiting for the prosecution to provide them with really important probative evidence to prove his whereabouts that they could not get on their own through the subpoena power. And it could be that the prosecution was dilatory or lollygagging and not getting it to the defense to show that he, in fact, has an alibi. But if that is the case, the prosecution had it all along. So they really can't cry foul if the very evidence that they need to refute the alibi was already in their possession.
Well, the defense has accused the state many times of multiple discovery violations. They want to strike the death penalty because of that again. So they've made many of these arguments.